Lawyers for Human Rights has appealed for assistance after Johannesburg High Court decision allowing the Helen Joseph Hospital to terminate life-saving dialysis treatment for an asylum seeker. Alem Ereselo from Ethiopia has lived in South Africa for 9 years. She approached LHR for assistance when the hospital first threatened to end her dialysis because she's not a South African citizen. We're joined now by Robin Lenahan, who is from Lawyers for Human Rights. A very good evening to you, and thank you so much for joining us. So, Robin, let's just start with the facts now. So, what is her status in South Africa?
So, her story is quite fascinating. She first fled Ethiopia 9 years ago, fleeing political persecution. So, she is an asylum seeker in South Africa. That distinction is not made all across the world, but it is in South African law. And essentially what it is that she's waiting for her final refugee status determination. As I say, she's been waiting for that for 10 years now. Refugee status would be a stronger status for her. It would mean that she would only have to renew her status every 4 years or so. At the moment, she has to renew her temporary asylum seeker permit pending the finalization of that status every 3 to 6 months.
And what is the reason for the delay?
Sure.
I'm assuming that 10 years we can comfortably speak about a delay in communicating her official status.
Yeah, absolutely. I mean, essentially the asylum system in South Africa is kind of broken apart. There have been a systematic closing of refugee receival offices, which is where people go to have their permits processed. There are 2 appeal processes in South Africa. So when you first arrive, you declare yourself to be an asylum seeker and you're given this temporary permit. And then, depending on what the decision is, it goes to 2 different bodies. And at the moment, neither of those bodies are fully functional. And so there's this massive delay, some estimated at like 59 years. Until people are getting their final status determination.
So how does she get to be a patient at the hospital? Was her status known or lack thereof?
So she first fell ill at the beginning of this year. Up until this point, she's only in her mid-30s and she's been very healthy up until this point. But she has a condition called lupus, and at the beginning of this year, her kidneys failed. She was admitted at Helen Joseph Hospital on an emergency basis and then started receiving dialysis, which is the life-saving treatment that somebody in her condition needs until she can get a kidney transplant. But after 3 months of receiving treatment, suddenly and without all that much explanation, suddenly her treatment was terminated. And the reason she was given is that she's an asylum seeker. The law around that is actually slightly more complicated. It's not that she can't receive dialysis because she's an asylum seeker, but that she can't receive a transplant. And dialysis is only given in the public sector in South Africa as a means to an end until she can get this transplant. And because she's an asylum seeker, as opposed to a South African citizen or a permanent resident, she can't even go onto that list. So she will never be able to receive it.
So we'll get to the law in just a moment, and the Constitution, what it really says, and whether or not a foreigner can get healthcare in South African public health system.
Yeah.
What did the High Court decide? Why did it agree with the Helen Joseph?
So the High Court, so we appealed this. We went to the court on an urgent basis because we needed our client to get dialysis right away. The longer she was out of treatment, the sicker she became, and also the less likely it will be that a transplant will work. So we approached the High Court on an urgent basis to ask that the High Court interdict, so in other words, stop Helen Joseph from refusing her treatment. Essentially, the High Court agreed with a judgment that happened 10 years ago, 12 years ago, in fact, at the Constitutional Court, called the Subramoni judgment, that determined that a man named Mr. Subramoni could be denied access to dialysis. I would say, and we are arguing, that the case is entirely distinguishable, but unfortunately the High Court, and we're appealing this judgment, agreed with the Subramoni judgment.
Without preempting your legal arguments, but what do you see as being distinctive in this case, and why she should be receiving dialysis?
I think there are kind of 2 ways to think about it. The one way is that there is no doubt in my mind that this case is distinguishable, although the Subramoni case may look on the face of it quite similar. The reason why the applicant in that case was denied access to dialysis was that he had a pre-existing condition. So he had a heart problem, and therefore he couldn't receive a transplant. And so the reasons were entirely medical. In our client's case, that's obviously not the case. She's incredibly healthy, her heart is fine. The only reason why she's being denied treatment is her legal status in the country. And so on one hand, you've got a medical distinction, and doctors are making these decisions, right? Which makes sense to me that a doctor would make a decision on a medical basis. But instead, what's happened is that doctors are making medical decisions based on legal principles.
So, as you know, we had what we saw in South Africa being labelled as xenophobic attacks, and part of the laments by those who felt truly that foreigners really take up space from South Africans, whether it's employment, whether it's healthcare services. What does the law really say? Are you able to receive healthcare services, whether you're a pregnant mother, whether you're receiving HIV or TB, And I'm also looking at SADC protocols, or are people taking advantage of the system, as some claim?
So I think for the sake, this is obviously a very big discussion. I think for the sake of this case and our argument, it's important off the bat to make a distinction between an economic migrant and an asylum seeker or refugee. Our client is not here because she wants to seek a better life. Our client is here because she has to be. And that's an important part of our argument. It's not that she's choosing to be here and therefore not choosing to go back to Ethiopia where she could potentially get dialysis and a transplant. It's that she cannot return. And she can't return personally, and she also can't return legally. So once you're seeking asylum in South Africa, going home questions that, right? You don't need to, if you need to go home, if you can go home, then we shouldn't offer you treatment.
But Section 27 of our Constitution says that everyone has a right to have access to healthcare services, including reproductive healthcare services, and no one should be denied emergency medical treatment. So if I'm a foreign national, irrespective of whether I'm here as an asylum seeker or a migrant or for whatever reasons, can I go in and demand any of these services?
So there are two aspects to Section 27 of the Constitution, Section 27.1 and Section 27.3. So Section 27.1 is about access for all, and Section 27.3 is about emergency health care. And those, you can't deny anybody, once they're in the Republic, access to emergency health care, including reproductive health. In the Subramani judgment, they decided that dialysis was not emergency health care. And so that's why the court is relying on that to deny our client access to dialysis. The difficulty is she will die without it soon. In the next few weeks, she'll die. And she can't return home. So she's being offered a death sentence. And that's how it's different to the Subramani judgment as well, is that it is actually emergency health care, and therefore everybody in South Africa should have access to it. The other important thing I think to remember is that our constitution is inherently a progressive constitution. And the thing about healthcare is that it's a progressively realizable right. Okay, so within our limited resources, we have to try and allow universal access. The Subramani judgment is from 12 years ago and therefore stands to be challenged because we have to progress beyond that.
So I just also want to go back and look at the SADC protocols just finally. So there's an understanding that, for instance, foreigners pay the full, if there's a certain amount that you pay as a South African citizen for a healthcare service, as a foreigner you'll pay the full amount. But does it preclude you from getting it, whether you can afford it or not, because you're a foreigner? Even within the SADC protocols that says whether you're from Lesotho or Swaziland, you should be considered as somebody who's eligible for these services.
So I'm not a doctor, and so it's very hard for me to determine what is emergency. But essentially the law says that, and the SADC laws, the SADC protocols are the same, is that you cannot be turned away on an emergency basis. And so if you turn up at a hospital, bloodied and bleeding, you have to be treated. But the problem is that we have to challenge the law when it comes to certain procedures, like we're doing with this one.
All right, thank you very much for speaking to us. Robin Lenahan is Candidate's Attorney at Lawyers for Human Rights.